Yes, counsel.
Thank you, Mr. Chief Justice and Justices. May it please the Court, I'm Sarah Lyons, representing the appellant mother. Her appeal comes to you from a single justice denying relief pursuant to Chapter 211, Section 3. And in this case, mother's fundamental right to family integrity was substantially violated. This happened when the juvenile court erroneously deprived her of the care and custody of her 15-year-old daughter.
Well, hasn't this case been dismissed?
It has, Your Honor.
Doesn't that make the case moot?
As I conceded in my brief, it does make this case moot, but it's still appropriate for this court to weigh in, as it did in the Brantley case, Brantley v. Hampton Division of Probate. And there, this court was proactive.
But in this case, if I understand correctly, the sort of record on which we could consider the arguments you make about the Boston Juvenile Court, it's not, I mean, the documents, the information wasn't before the single justice, and so isn't part of the record before us. Is that not so?
I apologize. I think I'm not quite getting your question. The information that the trial court had was given to the single justice.
But maybe I'm incorrect, but isn't part of your claim is that this isn't what has happened in your view to your client, it is not unique, that there is a larger issue? Is that correct or not correct?
Yes, that is. That the Boston Juvenile Court regularly denies parents their opportunity to
That's why you want us to reach the issue, is
exactly.
that right?
Yes,
and
Your
is
Honor.
that information was that information before the single justice, is that information part of this record?
Well, we did supply affidavits of counsel in order to, and you're right, Your Honor, that I believe was not before the single justice. But it is a routine practice that happens, as far as I can tell, only in this court. Other courts routinely rely on testimonial witnesses and properly admitted documentary evidence. And that doesn't happen in the Boston Juvenile Court. And you can see that in the affidavits of counsel. And it's concerning. And it's something that this court should weigh in on because these rights are so important. And this court is very aware of how important those rights are and has weighed in on issues of significant importance like this.
Have you communicated with the Office of the Chief Justice for the Juvenile Trial Court Department on
Your Honor,
this?
I have not on this. But I think that as in Brantley, this court said that there was no reason to wait for this to happen again. It is happening, and it's denying parents and children their right to be heard. The burden was shifted here. There was no evidence. The department believed that it had put in evidence, but they didn't. They didn't call a single live witness. They had 2 documents that they handed to the clerk, which, as you know, does not mean that it's into evidence. Mother was then required to call witnesses to rebut the allegations within those documents. Mother filed a written motion in limine, argued a motion to dismiss prior to the taking of any testimony. The judge should have ruled on that motion favorably and should have dismissed the case at that point. Though fortunately we were able to get the child home and back to the...
So when the judge didn't rule on that, did you come up here for any kind of 211.3 assistance?
Yes, Your Honor, that's how this case...
And then it's at that point that the case was dismissed?
At that point, the case was not dismissed. Mother then did a memo pursuant to Rule 221 And immediately after hearing back from the court, the case was dismissed and custody was returned to the mother. And I did reference that in my brief. I was concerned about the mootness issue, but I think it is appropriate, as this court has regularly weighed in on issues of significant public importance that are this is all but certain to repeat again, and it's likely to evade review, and that's the standard. And it would be appropriate for the court to provide guidance to future cases, to not allow this court to deprive parents of their right to a fair hearing.
And I gather your position is it's the Boston Juvenile Court that is the only juvenile court in the whole state that does it this way.
It's the only one that I'm aware of. And I did try to, I think we have many of the other courts across the state, the majority, if not all of them, that we referenced at the end of the record in those affidavits of counsel from other jurisdictions. So I would suggest that because the juvenile court committed an error of law here in erroneously relying on the 2 DCF documents, impermissibly shifting the burden to mother, that this court should weigh in and give guidance saying that that is not permissible, that DCF affidavits that are filed to initiate the care and protection petition are not admissible. They're pleadings, not evidence. And pursuant to the statute, pleadings have no evidentiary value. But this document is routinely relied on, and the hearsay statements within it.
Is the case that was decided last in the fall of 2009, I think is it care and protection of Zia?
Yes, Your Honor.
Is that relevant here?
Yes, we heavily rely on ZETA, and I think that
I'm not looking at the whole thing. So yeah, so that was brought up to the juvenile court judge?
The issue of ZETA, it was, I believe, in my motion limine. And this court heavily relies on ZETA, where this court made clear that only evidence that was properly before the court could be relied on. Here the court had no evidence, and yet took away custody, which is an incredible violation, an incredible intrusion in the mother and the child's rights. And it's impermissible, and I would ask that this court weigh in. I see that my time is up. If there are no further questions, I will
Thank you,
allow
Counsel.
Child's Counsel. Thank you.
Excuse me. Good morning. May it please the court, Tamara Garegian on behalf of the child, EM. And Your Honors, I was not trial counsel. I am only representing the child at the appellate level. And just to clarify to Justice Botsford's question of mother's counsel, when this was appealed to upon a 211-3, there was a live case in controversy. Therefore,
Right,
mother
I
did
understand.
not.
Yeah.
Okay, thank you, Your Honor. In response to the mootness argument asked by the Chief Justice, this case...
You were not a party to the 211-3 petition.
Oh, no, Your Honor, I was not. I was appointed...
The child was not a party to the 211-3.
The child's trial counsel filed a letter in support.
But didn't file a 211-3, was not a party to the 211-3.
That is correct, Your Honor, but the child does have a position. I was appointed by the Committee for Public Counsel to represent appellant child, where the child's position was one and the same as mother's, in that she wanted to be reunified with her mother, did not want to remain in the temporary legal and physical custody of the department. Therefore, in response to the mootness question, child's position is that where this is a significant issue of significant public importance, as this court held in care and protection of Erin, at this court's discretion, you may take it under your consideration, and I would ask that where this is likely to affect the course of future temporary custody hearings, it is worthwhile for this court to look at the procedure and the posture, the procedural posture that's ongoing in the Boston Juvenile Court. I personally practice in Essex County Juvenile Court, so I cannot speak to the procedure that's going on in the BJC. However, simply stated, at the 72-hour hearing, DCF had the burden of proof to show that this child was suffering an imminent risk of serious abuse or neglect if left in the custody of her biological mother. DCF rested its case on an affidavit written by the social worker and a court report under Chapter 119, Section 21A. Case law states that in care and protection cases, like all other civil cases, the general laws and the rules of law govern. Case law states an affidavit is a pleading, and a pleading is not evidence. Chapter 231, Section 87. Pleadings are not evidence, and it was wrong for the trial judge to admit that affidavit, and this is a wonderful opportunity for this court to clarify its opinion in Zeta, as Justice Botsford had asked about, or I'm sorry, I don't know if it was Justice Duffley, had asked about Zeta. In Zeta, this court did not address whether the affidavit was a pleading and whether it was admissible. This court simply stated it was error for the trial judge to rely on the affidavit where it was not admitted, nor could it be admitted. And I respectfully would ask this court to take a second look, clarify the holding in Zeta, because it is problematic for the party, the Commonwealth, where it bears the burden of proof, to simply submit an affidavit, which is a claim, a prayer for relief, and a statement of allegations, and say, Your Honor, this is our affidavit, we rest. It's problematic where children are being removed from the care and custody of their parents at a very low threshold burden of proof, and in effect it is switching the burden, shifting the burden, I should say, to the parent. As if you read the transcript, that's exactly what seemed to have transpired.
Thank you,
I'm sorry, Your Honor. I thought I was going to have a little bit more time.
All right.
May it please the court, my name is Muriel Finnegan. I represent the Department of Children and Families in this case. Let me commend to you, first off, that this case is moot. If many of you are questioning why we're here, so is the department. The care and protection case was dismissed 5 months ago.
Well, shouldn't we be concerned about the practice and that is apparently regularly occurring in that court?
No, Your Honor, you shouldn't be concerned about the practice. The practice is consistent with the care and protection of Bruce, which holds that materials that are generated by individuals who conduct an investigation into the care and custody of children may be admissible in court, and also that the authors of those documents may or may not be called as witnesses.
So could I understand you? Your position is not that it's moot, but there's also nothing here that merits our consideration, because everything that was done in that proceeding, by what I understand to be an experienced judge, so this wasn't a result of inexperience, was okay?
That is correct, Your Honor.
Is it I'm sorry, you go ahead.
Could you just explain so I understand? So you're saying these reports were provided along the lines of a court investigator's reports?
Yes, Your
Under
Honor.
Section 21.
Yes, Your Honor.
And Section 21 says that then the author of the report is presented for cross-examination, doesn't it?
That is a holding of care and protection of Bruce. It's one of the requirements of care and
that
protection
happen
of
here?
Bruce. And in connection,
Did that happen here?
the social worker was thoroughly examined by Mother's Council and Child's Council. They chose to examine the social worker in their case of chief. They could have.
They chose to do that?
Before the department rested their case, they could have called the witness and cross-examined the witness, but they chose to do it by direct examination. But the witness was in the courtroom the whole time during the department's presentation and was made available.
Could I just ask you, counsel, I mean, this part would be important, but the judge says whether, it's up to you, speaking to counsel. I have the documentary evidence, I've read it. The department's not obligated to call any witnesses. I don't see that as consistent with your view of what occurs in this court, or at least not at that particular juncture.
I didn't quite hear the end of your question, Your Honor. I'm sorry.
This strikes me as inconsistent with what you're saying is the correct way to proceed.
If you're going to cross-examine, the witness has to be called by somebody who has some responsibility for direct examination, I think.
Right.
Well, as I said, the Child's Council and Mother's Council could have called the witness at the time before the department rested and cross-examined.
So you're saying that the witness was actually there and was available for examination?
That's correct, Justice Court. It was
and-
available the whole time.
Okay.
And what does care and protection of Bruce say about that? Does it say that once the report goes in, that the author of the report also has to testify for the department, or is it enough that the author of the report is available if either the parent or the child chooses to call that person in defense or in its own case? Does it make any?
Care and protection of Bruce, Your Honor, makes the document admissible and places the burden on the opposing party or the one who wants to challenge the document that's admitted, places the burden on them to call the witness. And that's exactly what Judge Lawton found in this case.
Well, then it's not cross-examination. I mean, but maybe this is just technical, because theoretically the department could call the witness, say, is this your report? The person says, yes, it is. It's admitted, and then sits down and the Mother's Council cross-examines.
I don't think that the department is required to simply call the social worker to identify the document. I think the burden is on the opposing counsel to challenge either the foundation or the substance.
It's a technical question, because cross-examination usually means somebody else has called this witness, and then the cross-examiner is the second up. But could I ask you this question? Is the allegation is that this only happens at the BJC? Is that, I mean, you represent the department. Can you tell us anything about that?
Your Honor, I would commend to the court my motion to dismiss those pleadings, the affidavits of those counsel. It's completely unfair to put them in the record appendix. They weren't before the trial judge. They weren't before the single justice. The department has had no opportunity to address these documents in any way, shape, or form.
Counsel,
So I'm asking you not to consider them.
Even if we didn't, just to, if I understood you correctly, in reading the transcript, you do have the transcript of this proceeding, and your position is that everything that, and you may be correct, that everything that occurred in this proceeding is fine. So after the submission of the documents, just handing them to the court is what happened here. Then there was a motion to dismiss based on there being insufficient information in those documents, and that was declined. The judge would not proceed on the motion, right? Saying if you want to call people, you essentially rebut this information. Doesn't that shift the burden?
It does not shift the burden of proof? No, Your Honor, I don't believe it shifts the burden of proof. And if that's the case, the procedures that were followed here were totally consistent with care and protection of Bruce. And I ask you, and basically opposing counsel admits that because they suggest at one point in their brief that you have to overrule care and protection of Bruce in order to provide a remedy for them in this case.
Let me ask you, did the department indicate that the affiants were in the courtroom and were available for cross-examination?
Yes. Yes, Your Honor. All parties were aware that the social worker was in the courtroom. It's part of the record. And all parties were aware that the documents were going to be admitted into evidence in advance of the hearing. That's why counsel was able to come with a motion in limine for Judge Lawton, a detailed motion in limine, which the judge ruled on. The judge followed the procedures in care and protection of Bruce by redacting opinions from the documents and also by having the social worker examined by opposing counsel, as they did. And they didn't ask one question about the foundation.
Is Boston the only court that does it this way?
I am not a trial counsel, Your Honor, so I wouldn't have any personal knowledge of that. I think it is basically irrelevant to these proceedings for a couple of reasons. There's nothing wrong with the procedure, so it doesn't matter if Boston is the only court that does this.
So essentially, the counsel here has to request the opportunity to cross-examine. That's what Bruce says. You have the right
That's
to cross-examine,
correct.
you just have to request it.
That's correct, and they did so in this case.
They didn't. They made the witness was available, but they chose not to request to cross-examine.
That's correct.
They called the witness in the direct case?
That's correct. This is not a case where there's a matter of public importance or the capable of
Can I just go back to that, what Justice Cordy just asked you? As a matter of practice in the Boston Juvenile Court, if a parent calls this person on direct examination, are they allowed to cross-examine them?
Are they allowed to cross-examine? I don't have any direct personal knowledge of that.
Okay.
I think that what Judge Lawton said, he referred to, you can call them and cross-examine them. They just chose not to do that in this case. I don't have any direct personal knowledge of the proceedings in Boston Juvenile Court. And again, I come into this court that it is not fair to use them because it wasn't available either to the judge or to the single justice in this case. This is not a matter of major public importance, nor is it capable of a petition but evading review. Mother herself took advantage of the 72-hour proceeding. Okay. It looks like I'm out of time, so let me just wrap up very quickly. By saying that contrary to the assertion of mother and child in their briefs, the DCF affidavit was not a pleading. According to their own definition, it's not a pleading. It is not the document that initiates the case or gives notice to the other party of what the allegations are. I myself filed this request for a supplemental appendix, including what is the pleading, what I believe to be the actual pleading in this case, which is the actual care and protection petition. Moreover, by the definition of the pleading, the department is not bound by the care and protection petition itself. There's certainly numerous cases that suggest we have to present additional, more current evidence of the parent's unfitness at the time of trial. And I also want to correct my sister. I don't believe you'll find anywhere in the transcript that counsel mentioned to Judge Lawton that they thought this particular affidavit was a pleading. The motion in limine was directed to the issue of hearsay and not to the fact that they suggested this was a pleading.
All right, I'm going to stop you there. Thank you very much. All right.
Thank you very much, Your Honor.